Your Honor, I would just note for the record that my client is recently remarried and her new last name is Tinsman. She had to leave her previous job, which still had her making significantly less money than Mr. Gentry, as a result of that. Since that agreement was reached, my client is on has a different job. She's remarried. She has a baby. Right now, the parties are required to each pay 50% of any child care expenses. That was an agreement that they reached in their original judgment of divorce. We're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan child care formulation.
Calling case 2022-2134 DM, Aaron Gentry versus Peter Gentry. Today is Monday, July 22nd, 2024 at 9:50 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. This matter is before the court on the plaintiff's motion to modify support with regard to child care. Ms. McNiff.
Your Honor, I would just note for the record that my client is recently remarried and her new last name is Tinsman. This is really a pretty simple motion. Right now, the parties are required to each pay 50% of any child care expenses. That was an agreement that they reached in their original judgment of divorce. She had to leave her previous job, which still had her making significantly less money than Mr. Gentry, as a result of there not being sufficient PTO, sufficient sick time. She at one point was taking care of the children when they had COVID during Mr. Gentry's parenting time. The kids have had some significant medical issues, some like tube surgery, things like that she's had to take time off for, and she simply couldn't do it with the previous job. So she took a remote job so that she could meet those obligations. We've also been in court a lot, which was a difficulty for her and with her previous job. So we're simply asking that the child support provision not be 50-50, that it be pursuant to the appropriate Michigan child care formulation that would assign the parties percentages. We do have this matter currently in front of referee Snyder on a change of domicile request, change of custody, change of parenting time. However, this particular part of the child support formula was not an issue. And I think in order to get it there, either the court needs to rule on it or send it to referee Snyder.
Okay, thank you. Ms. Thomas, any response?
I do, Your Honor. I don't think it's as simple as what Ms. McNiff purports it to be. Our answer to the plaintiff's motion certainly sets forth the defendant's position regarding the 50-50 child care. However, I would add that to clarify, I just want to clarify a couple of things. First, at the time of filing our answer, this motion hearing was scheduled for last week. So we had said there was 9 days before we'd be in front of court again. We're actually in front of Mr. Snyder again on Wednesday of this week. And so there's no reason that this motion couldn't have been brought at that hearing. This is just an extra motion for no particularly good reason other than it cost Mr. Gentry a lot of money. But more to the point, the parties negotiated. And they reached, it was by the judgment of divorce was entered by consent. And part of their negotiation was that because Mr. Gentry for a while was working at home, because that was part of what his job was doing, that's not the case anymore. And there was some variables, but the parties agreed that it should be 50-50. And that's what they agreed to that. And that's part of the other issues in the case settled because of that. So therefore, that was a negotiated agreement and it wasn't part of it. And if you look at the uniform child support order, although it's purported that it's in there, it's not in there. And if you look at the formula that's attached, the calculations attached, it's not on there. It does not say that at all because the parties had agreed that it was going to be 50-50. If it was summer, if it was before and after school, whatever it was going to be, it was going to be 50-50 because that was part of the settlement that they reached based upon all the totality of the circumstances of their particular case. For clarification, in plaintiff's motion regarding change of domicile, she specifically requested relief as it relates to child care in this matter. And Mr. Snyder has in fact heard testimony as it relates to the issue of child care. In plaintiff's motion regarding change of domicile legal residence, although she indicates that she's also asked for custody and parenting time, in her motion, that's not true. In her motion, she acknowledged childcare expenses for the children under the age of 12 are to be paid 50-50 and specifically requested reimbursement regarding questionable childcare expenses. So this issue of childcare between these parties is already in front of Mr. Snyder, and he's already heard testimony. So to have another motion, another motion that we can again prepare for another motion, another thing is ridiculous. And also, frankly, one of the many reasons that Ms. Gentry used to persuade this court that she should be allowed to take the kids with her to her new boyfriend, now husband's home in West Virginia, was that she was offered a job less than 5 minutes away from her then boyfriend's home. And it was at a State Farm agency, and it was contingent upon her being able to move there. And then she quit her job at State Farm here. And that was all as a furtherance of her career. That was one of the big things that the reason that she, was going to do this. And now she quit her job. She worked at another job. She worked full time. She said she was going to only work part time. There's been like, it was this and it's this and this. And it's like, and the testimony and the actions don't match. And she was going to have, and specifically, I believe that she said that plaintiff alleged in her motion that her fiance is, quote, supportive of a part-time work arrangement for her. His career is stable and he is well compensated, which will enable a more relaxed professional schedule for me. Yet she quit her regular job. She took a full-time independent contractor job, if you will, with no benefits. And then now and because of this financial affordability, because of her fiance's and now husband's income. And now here we are. We'd already agreed on this. This is something that they negotiated before Lisa was involved, before Ms. McNiff was involved, before I was involved. And now here we are saying, oh, well, wait a minute, that's not affordable now. I mean, I think she needs to use her new financial windfall and she needs to suck it up.
If you haven't caught on yet, the new boyfriend makes enough income, enough so that she can work less. Yet she still wants her ex-husband to make up the difference, even after they agreed on going 50-50.
This is, again, 1/2 share of childcare expenses is what they agreed to. And it's not included in the Uniform Child Support Order. This issue with regard to who's going to pay what for last summer is before referee Snyder. So this issue was already in front of him. And this is, again, another motion that the plaintiff has brought that we have to prepare for, get ready for. And we're just asking that the court uphold the current order of the court, the judgment of divorce, which is the court order by consent of the parties. Although Ms. Gentry indicated that she has paid her 50% of childcare, she has not. She's not paid anything this summer at all. And now we have attorney fees in addition, and it's the same subject matter that's already before Mr. Snyder, that he's already taken testimony as to these issues, in fact.
Yeah, I don't have to have that read. I've heard that probably 3 times already, Ms. Thomas. What I'm going to do in this matter is, obviously, the judgment of divorce provides for 50-50 in child care costs. It was by the consent of the parties. The court has not heard any reason why the court should invade and modify a judgment that was entered into by agreement of the parties, consideration of all the issue. The court is going to deny the motion. Ms. Thomas, you can prepare that order and submit under 7 days.
Your Honor, will the court consider our request for attorney fees?
I'm not going to at this time. Yeah, I don't have to have that read. I've heard that probably 3 times already, Ms. Thomas. What I'm going to do in this matter is, obviously, the judgment of divorce provides for 50-50 in child care costs. It was by the consent of the parties. The court has not heard any reason why the court should invade and modify a judgment that was entered into by agreement of the parties, consideration of all the issue. The court is going to deny the motion. Ms. Thomas, you can prepare that order and submit under 7 days.
It's upsetting how the judge refused to even hear any arguments requesting for her to pay his lawyer fees. Having another child should never be used as part of the basis for asking for child support from the other children's father. Also, Dad's attorney needs to get to the point. I don't think she would have stopped talking if the judge didn't cut her off. What do you think? Was this the right decision? Let me know in the comments below. If you made it this far, be sure to subscribe for more videos just like this one. I'll see you next time.